Lesson: Navigating International Dispute Resolution Mechanisms. Navigating international dispute resolution mechanisms is an essential skill for HR leaders, particularly those involved in managing employment law across borders. These mechanisms provide structured processes through which disputes can be resolved efficiently and effectively. As employment becomes increasingly globalized, understanding these mechanisms is crucial for HR professionals who must handle conflicts that arise between multinational employers and employees from various jurisdictions. This lesson explores actionable insights and practical tools that HR leaders can implement to enhance their proficiency in international dispute resolution. One of the primary frameworks for resolving international disputes is arbitration. Arbitration offers a private, binding resolution mechanism that is often preferred for its confidentiality and speed compared to traditional court litigation. The New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards is a cornerstone of international arbitration, ensuring that arbitral awards are recognized and enforceable across its signatory countries. HR leaders can leverage arbitration clauses in employment contracts to preemptively agree on resolving disputes through this method, thus avoiding jurisdictional uncertainties and lengthy litigation processes. To effectively incorporate arbitration in employment agreements, HR leaders should focus on drafting clear and enforceable arbitration clauses. These clauses should specify the governing rules, the seat of arbitration, and the language in which proceedings will be conducted. For instance, choosing the rules of a reputable arbitration institution, such as the International Chamber of Commerce or the London Court of International Arbitration, can provide a structured framework for the arbitration process. In drafting these clauses, HR leaders should consult legal experts to ensure compliance with local laws and international standards, thus safeguarding the enforceability of the arbitration agreement. Mediation is another valuable tool in resolving international employment disputes. Unlike arbitration, mediation is a non-binding process where a neutral third party facilitates negotiations between disputing parties to reach a mutually acceptable solution. Mediation is particularly effective in preserving employment relationships, as it encourages collaboration and communication. According to a study by the International Mediation Institute, mediation has a high success rate, with approximately 70 to 80% of mediated disputes resulting in a settlement. HR leaders can incorporate mediation clauses in employment contracts or company policies, promoting mediation as a first step in the dispute resolution process. For practical application, HR leaders should establish a network of qualified mediators who are familiar with cross-cultural dynamics and international employment law. Engaging mediators who understand the nuances of different legal systems and cultural contexts can significantly enhance the likelihood of reaching a successful resolution. Additionally, training HR staff in mediation techniques can empower them to facilitate informal mediation sessions, potentially resolving disputes before they escalate. In cases where arbitration or mediation is not viable, litigation in domestic or foreign courts may be necessary. However, navigating international litigation involves complex jurisdictional issues and potential conflicts of law. The choice of forum and applicable law can significantly impact the outcome of a dispute. HR leaders should be aware of the doctrine of forum non-convenience, which allows courts to dismiss cases if another forum is deemed more appropriate for the dispute. This doctrine can be particularly relevant in employment disputes, where one party may seek to litigate in a jurisdiction perceived to be more favorable. To address these challenges, HR leaders should work with legal counsel to conduct a thorough analysis of potential jurisdictions and applicable laws before initiating or responding to litigation. This analysis should consider factors such as the location of the employment relationship, the domicile of the parties, and any contractual choice of law provisions. By understanding these elements, HR leaders can develop a strategic approach to litigation that maximizes the likelihood of a favorable outcome. Understanding the principles of private international law, also known as conflict of laws, is crucial in navigating international dispute resolution mechanisms. This area of law determines which legal system and which jurisdiction's laws are applicable to a dispute. For HR leaders, this knowledge is essential in drafting employment contracts that include choice of law and choice of forum clauses. These clauses provide predictability and reduce the risk of protracted jurisdictional disputes, thereby ensuring that conflicts are resolved under the most appropriate legal framework. HR leaders must also consider the impact of international treaties and conventions on employment disputes. For example, the Hague Convention on Choice of Court Agreements aims to ensure the effectiveness of exclusive choice of court agreements between parties in international commercial contracts, including employment agreements. By incorporating such agreements into employment contracts, HR leaders can provide certainty and clarity regarding the resolution of disputes, thus minimizing the risk of conflicting judgments from different jurisdictions. In addition to legal frameworks, HR leaders should be aware of cultural differences that can influence dispute resolution processes. Cross-cultural communication skills are vital in understanding the expectations and preferences of parties from diverse backgrounds. Research has shown that cultural factors can significantly impact negotiation styles, decision-making processes, and perceptions of fairness. HR leaders can benefit from cultural competency training, enabling them to navigate these differences and facilitate more effective dispute resolution. Case studies provide valuable insights into the practical application of international dispute resolution mechanisms. One notable example is the case of the French company Alstom, which faced a dispute with its American employees over allegations of unfair dismissal and discrimination. The company opted for mediation, successfully resolving the dispute through a negotiated settlement that avoided costly litigation and preserved its reputation. This case highlights the importance of selecting an appropriate dispute resolution mechanism and engaging experienced mediators to achieve a satisfactory outcome. Statistics also underscore the effectiveness of alternative dispute resolution methods in international employment disputes. According to the American Arbitration Association, employment disputes resolved through arbitration typically conclude faster than those resolved through litigation, with the average arbitration case lasting about 8 months compared to 18 to 24 months for court litigation. These findings demonstrate the potential for significant time and cost savings through the strategic use of arbitration and mediation. In conclusion, navigating international dispute resolution mechanisms requires a multifaceted approach that combines legal expertise, strategic planning, and cultural awareness. HR leaders must be proactive in incorporating arbitration and mediation clauses into employment agreements, establishing networks of qualified mediators and arbitrators, and conducting thorough legal analyses when litigation is necessary. By leveraging these tools and frameworks, HR leaders can effectively manage international employment disputes, minimizing risks and fostering positive employment relationships. Ultimately, the ability to navigate these mechanisms enhances organizational resilience and ensures compliance with international employment law.